Hello to everyone, and welcome to this first episode of the Archipel Talks. The purpose of these talks is to discuss issues related to our practice with a very pragmatic approach and top-notch legal practitioners. Our first guest is José Ricardo Feris. For most of the arbitration practitioners, he does not need any presentation. For the few of you that do not know him yet, he is partner at Square Patton in Paris. He's currently the vice chair of the ICC Commission on Arbitration and ADR, and he is teaching arbitration at Sciences Po. Most importantly, for the purpose of our talk, he has been 13 years at the ICC Court. His last role at the ICC Court was Deputy Secretary General. And during his stay at the ICC Court, he supervised and scrutinized more than 1,000 arbitration proceedings and arbitral awards. We feel very grateful and we're very happy that he's here with us. Thanks a lot, José Ricardo, for accepting our invitation.
It's an honor for me to be here. Thanks for having me, Giulio. It's we've been seeing each other and chatting and we've coincided in many places, in many parts of the world. So it's a pleasure for me to start the year with such a friendly talk here with you and with your colleagues at Archipel.
Thanks a lot for your kind words, José Ricardo. Our talk with José Ricardo will be focused on ICC-related issues. And in this first episode, we're going to talk about appointment of arbitrators under the ICC rules, with a special focus on direct appointment of arbitrators by the ICC Court. José Ricardo, I understand that direct appointment now it's very common. The ICC in the past was relying a lot on ICC national committees. Can you please tell us more about what was happening in the past and what is this evolution of the method of direct appointment?
Let's remember that 20, 30 years ago, 40 years ago, the world was not as interconnected as it is now, generally speaking. And in terms of arbitration, the world was not, or the arbitration practice was not as generalized and as globalized as it is now. Therefore, the ICC Court, in order to appoint the best specialists from different parts of the world, from different jurisdictions, relied on national committees to find the people, to find the appropriate people. Let's remember that the ICC is a truly international arbitration organization, so it administers cases from all over the world. So it was difficult for the ICC court to be able to know which were the top arbitration specialists in every single jurisdiction in every single country. I would like to also highlight one additional benefit of the National Committee system, which is has to do with governance of arbitral institutions. We all know that one of the main principles of good corporate governance is to make sure that the decisions are not centralized in one single person or one single body. So in terms of corporate governance, it was also quite healthy for the court to rely on other bodies in order to make the appointments. As you know, one of the issues that we've been fighting in the international arbitration field is the lack of diversity, right? So the fact that the ICC had these national committees and that the ICC could actually, go to basically any jurisdiction in the world. The ICC has over 100 national committees, and ask those national committees, do you know someone that would have this characteristics that you would be able to propose? Actually contributed to the increase in diversity in the arbitrator appointments.
Going back to the question that I asked you at the beginning, so basically then direct appointment was very rare because basically the idea was to go to a national committee and ask for
Correct.
a name. You were going to a national committee on the basis of several criteria, such as the law applicable, the seat of arbitration. Then I understand that in 2012, there was a first amendment to this practice, let's put it this way,
Yes.
and then the issue evolved. So
Correct. The practice evolved until 2012. The main method of appointment was appointment through national committees. And the ICC knew that it had, because of the development of investment arbitration and because of the increase in commercial arbitration involving state and state entities, the ICC knew that it had to address some of the concerns that state and state entities had with respect to ICC arbitration. And one of the concerns that states and state entities had was that ICC is a community of business people, right? It represents business around the world. And there was a perception that because appointments were being made through national committees, and national committees were basically groups of business people, um, that those appointments somehow were being made by, the people that were normally on the other side
you
of
don't
the
want business
cases.
people to appoint business people that they are acting against, that they are
Exactly, in
showing
the
state on
arbitration,
business.
right?
Yeah.
So
Okay.
that, but I can tell you, it was mainly a perception issue.
No, of course.
We never saw a real problem because, when the court asks a national committee to appoint a particular arbitrator, of course, the court will send a list of the criteria that the appointment needs to meet. So the court was, making sure that there were not there were the people that were being proposed were people that actually had the right profile in order to, let's say, decide a case involving a state or state entity. But nevertheless, that was a perception issue. We thought it was a valid concern, and that concern needed to be addressed. So it was addressed by including an exception in the ICC rules that allowed the court to directly appoint arbitrators precisely when there was a state or a state entity involved in the case. Uh, I would say that still the uh, system of the ICC still relies in a majority of the cases in national committee proposals. But of course, the number of direct appointments has increased significantly in the past years, and that has forced the court and the secretariat of the court to basically develop an internal policy and an internal practice as to how to go about those direct appointments, right? Because, if you had this system of checks and balances with national committees, you need to make sure that internally, when you do a direct appointment, there is also a system of checks and balances.
Such as, for example, that you have to make sure that there is a turnover. So can you tell us a bit
Yes.
about criterias and
Yes.
yeah,
Yes. For instance, I guess it all starts with the team administering the case. The team administering the case needs to put together a list of arbitrators, and that list needs to comply with certain criteria. First of all, the ICC needs to make sure that not the same people are appointed again and again. So the teams in the secretariat will consult each other and will make sure that one particular arbitrator is not appointed, more than once per year. Um, so there will be some consultation with other teams to see whether a particular individual has been appointed already by the court in another case in another team within which period of time. As you know, the ICC court is a signatory of the pledge, and so that is also being taken into account when putting together the lists. The ICC court has gone even further when it comes to gender diversity. It has now, You have now gender parity at the ICC court and at the in terms of the vice presidents of the court, but in terms of the total membership of the court. So gender diversity is also very important criteria when putting together the lists. Um, so these
How
are
it works
two.
with the legal diversity in the sense that we all know that the most common seat are 5 jurisdiction, the most common applicable law are 4 or 5 applicable laws. How do you end up appointing practitioner from jurisdiction that are not the friendly jurisdiction, or where, I mean,
Correct. No, no, no. That is a very important point. I very often when I was at the ICC, there's a statistic that bothers people, and when you look at the nationality of arbitrators, very often you will see that, let's say, over 50 or more percent of the arbitrators will come from Western Europe and the United States. But however, that statistic does not match the jurisdiction, the nationalities of the parties, right? And I've always said that one element that very often influences the nationality of the arbitrators is the seat of arbitration. And the other element, as you correctly pointed out, was the applicable law. So there is a tendency that when you have Paris as place of arbitration, London, Geneva, New York, Singapore, you have a tendency of appointing arbitrators, at least the chair or the sole arbitrator from that jurisdiction. And the ICC court has been fighting against that practice because, it's not necessarily the case that you need to have an arbitrator from that nationality at least. If
but
London is
things
the
will
place of
change because we
arbitration.
are so many expat and foreigners working in
Exactly. So
arbitration in other
you
countries that,
start
yeah,
you start with the expats
yeah.
in Geneva, in Paris, in London. There are many expats. So in terms of nationality, at least of the arbitrators, you can certainly expand the pool because those jurisdictions have a very important number of expats. So that is a starting point. But then you also have arbitrators in different parts of the world that would have different profiles and different experiences. And the fact that the arbitrator is that the seat of arbitration is in Geneva doesn't mean that you cannot have an arbitrator based in Paris or in Brussels or somewhere else in Europe, right?
So the team is putting together this list of names, checking that basically these people, they have not been appointed during the last year by the court, and then they have to take into consideration other criteria. The
Of
ICC
course.
obviously is,
The profile,
yeah.
the background, the language, everything that,
and then these
who the co-arbitrators are, that's also
And then these
uh,
names are discussed during the meeting of the secretariat on Tuesday, and then basically at the court
it's
session on
discussed, yeah,
Thursday.
it's discussed with the management, with the secretary general, deputy secretary general, with the president of the court, where is very heavily involved in these discussions, and then the proposal is put forward to the court. Very often the court will want to know which other candidates have been considered. Sometimes the secretariat will bring to the court more than one candidate. That's 2 or 3 candidates for the court basically to choose, and the court will take a final decision on who
So
to
when the
appoint.
team is just suggesting this list of names, then there is a sort of brainstorming between all the members of the secretariat, namely counsel and deputy counsel of each team, plus the managing counsel, the deputy secretary general, the secretary general, discussing those names, and they're basically, you come up obviously with a safe list of name because there are so many people involved in the discussion.
Yes,
Yeah, yeah,
I
of
mean,
course.
very often the team will come up with a list. It used to be the case with me. When you're the deputy secretary general, you're in charge of the functioning of the 10 teams. So now I think it's 11. Now I think we're at 12 teams. I think with the opening of Abu Dhabi now, it's probably 12 or 13 teams at the secretariat. So you are in a position where you know very much what's going on in every single team. So sometimes I would see a name, and I would then call that team's attention to the fact that we appointed that person last week. But also one of the due diligence that the teams will perform, and also that the knowledge of the management is very important, is whether that arbitrator is performing, is either currently or recently performing their duties well. For instance, it sometimes it's the case that you are aware that an arbitrator is currently delayed, heavily delayed in various cases, but that's not an arbitrator that will be appointed by the court.
Thanks a lot for watching this first episode of the Archipel Talks with José Ricardo. During our second episode, we're going to discuss with him the scrutiny of arbitral awards by the ICC. If you like this episode or you want to know more about the next episode, please follow us on our LinkedIn page or subscribe to our YouTube channel. Talk to you soon.